Okay, calling the case of Marks versus Sonny's Rooftop Bar. I'll take appearances from counsel.
Yes, Your Honor. Good morning, Your Honor. My name is Pandey. Today, I'm joined by my colleague, Rishi Subramanian, who will be acting as my second chair.
Good morning, Your Honor.
Together, we represent the plaintiff in today's case, Ethel Marks, on behalf of her deceased daughter, Jessica Marks.
Very good. And for the defense?
Good morning, Your Honor. My name is Aiden Connors. Today, I'm joined in court by my co-counsel, Lindsay Reamer.
Good morning, Your Honor.
Good morning.
As well as Miss Sunny Mehta, the owner of Sonny's Rooftop Bar and the party representative for the defense in today's case.
Very good. Are there any preliminary matters to attend to before we start the trial?
Yes, Your Honor. The plaintiff has a few.
All right.
Pursuant to Rule 603, can we assume that all witnesses have already been sworn in?
We can.
Your Honor, we'd also like to take note of the fact of Stipulation 14, which states that Jessica Marks was born on January 20th, 2000, and was thus 19 years old in 2019.
Very good.
We'd also like the court to take notice of pretrial order number 3, which says that the court has dismissed the second affirmative defense, which alleged contributory negligence on behalf of Morgan Levin.
All right.
And finally, Your Honor, we'd like the court to take notice of pretrial order number 11, which says exhibits 1, 22, and 23 have already been pre-admitted.
Very good.
With that, the plaintiff is ready to proceed.
Any additional matters for the defense?
A few pretrial matters, Your Honor. First, we'd like to invoke Rule 615, which constructively sequesters all witnesses barring party representatives. So Ms. Mehta will be joining us in trial today. We'd also, excuse me.
Yeah, go ahead.
We'd also like to ask the court's preference. When screen sharing documents for identification purposes, can we assume that's outside the presence of the jury, or should we ask each time?
You can assume it's outside the presence of the jury.
And with that, the defense is ready to proceed.
Okay, then I will hear opening statements and remind folks that the competition likes to have people do that in speaker view. Watch that in speaker view. Okay.
Your Honor, may I have a moment to readjust?
You may take as much time as you need.
Thank you. They didn't check. They didn't stop. They didn't care. On March 24th, 2019, a 19-year-old girl stumbled out of Sonny's Rooftop Bar in Malibu. She was slurring her words. Her judgment was impaired. She was loud. She was boisterous. Her eyes were red. She sat behind the wheel of her black Chevy Impala, pulled out of the parking lot, and began driving. Minutes later, she lost control. Her car swerved off the highway and crashed into a ravine. In just moments, Jessica Marks was dead. But today, the evidence will show that Jessica's death wasn't her own fault. And that's why her mother, Ethel Marks, has filed a lawsuit against Sonny's Rooftop Bar, the defendant in today's case, to seek justice on her daughter's behalf. Members of the jury, you're going to learn that Jessica Marks was underage, but was served alcohol by Sonny Mehta, the owner of Sonny's Rooftop Bar, because the defendant didn't thoroughly check Jessica's ID. You're going to learn that the defendant watched Jessica as she slurred her words and stumbled with each drink, but still didn't stop serving Jessica. You're going to learn that the defendant let Jessica Marks leave the bar and get behind the wheel of her car because they didn't care. They didn't check. They didn't stop. They didn't care. And that's why we as the plaintiff have brought a claim of wrongful death. All that means is that Sonny's Rooftop Bar is responsible for Jessica Marks' death since they were the ones who overserved her despite her being a minor. And there's three things that we as the plaintiff have the burden of proving today. First, that Jessica Marks was obviously intoxicated, meaning that she was showing symptoms which would lead a reasonable person to conclude she was drunk. Second, that Sunny's Rooftop Bar continued to serve her alcohol despite her being obviously intoxicated. And third, that the alcohol she consumed was a substantial factor in her death. And we have to prove each of these three elements by preponderance of the evidence. Preponderance of the evidence simply means that you believe our case is more likely than not. More likely than not that the defendant didn't check, didn't stop, and didn't care. So let's start with Jessica Marks's obvious intoxication. Today we'll call Morgan Levin to the stand, Jessica Marks's best friend. And Mr. Levin will tell you how much alcohol Jessica drank and how the symptoms of intoxication Jessica was showing were the exact ones that Sunny Mehta looks for in an intoxicated person. Second, the defendant continued to serve Jessica alcohol. You'll hear today that Jessica stumbled down the stairs at Sunny's Rooftop Bar and yet still was served a few seltzers after. You'll hear that the defendant even asked if Jessica was going to drive that night and yet still served her shots. And finally, that the alcohol was a substantial factor in Jessica Marks's death. To prove that, we'll show you just how much alcohol was in Jessica Marks's blood at the time of her death, which would make it more likely than not that the alcohol was the only factor that led to her death. Now, I've talked a lot about what the facts of today's case will show, but regardless of what happens here today, there is one fact that will not change. Jessica Marks is no longer with us. Her parents will never get to see her graduate college, see her get married, see her have kids. She was a light in her family's life, one that can never be brought back. But there is one thing only you can do, to bring justice for Jessica and her family. That's why at the end of today's trial, I'll come before you and ask you to find the defendant liable because they didn't check, didn't stop, and didn't care. Thank you.
Whenever you're ready.
Yes, Your Honor. May it please the court, counsel, and members of the jury. You can't stop what you can't see. On March 24th, 2019, Sunny Mehta, the owner of Sunny's Rooftop Bar, spoke to Jessica Marks 10 times. Not once did she suspect that anything was wrong. 10 times, Miss Mehta took orders to Ms. Marks's table, spoke to her, looked her in the eyes, and didn't see someone who was drunk. Didn't see someone who needed to be cut off. She didn't see anything wrong. Now, a moment ago, Mr. Pandey told you that this case is about whether Sunny's Rooftop Bar didn't check, didn't stop, and didn't care. He mentioned that they let Ms. Marks leave their bar. But members of the jury, that's not what this case is about. It's not about what we know now. This is a case about what those bartenders knew then. What they saw then. Because members of the jury, you can't stop what you can't see. And that question of what they knew, of what they saw, is so important today because the plaintiff is suing my client, Sunny's Rooftop Bar, for wrongful death under the California Dram Shop Act. Now, the plaintiff doesn't have to prove that they didn't care. The plaintiff doesn't have to prove that they let Ms. Marks leave the bar. The plaintiff has to show you it's more likely than not that Ms. Marks was so drunk, so publicly impaired, so clearly inebriated that any reasonable person at the bar that night would have looked at her and thought to themselves, that girl's too drunk to keep drinking. They've got to show you that the bartenders at Sunny's bar looked at Ms. Marks, had that very thought, and kept pouring her drinks. They're not going to be able to meet that burden today. And to show you why, we are going to ask and answer 3 questions throughout today's trial. First, what did the bartenders actually see? Today, we'll call Ms. Mehta herself to the stand. She'll tell you her story of March 24th, how she's trained to see when a customer needs to be cut off, how she spoke to Ms. Marks time after time after time and didn't see anything wrong. Second, how much did Jessica Marks really drink? Because we expect that the plaintiff is going to show you a pretty long list of drinks today. We expect they're going to try and tell you that Ms. Marks had most of that alcohol, but I want you to listen for any concrete evidence that that story is true. Because you'll hear that the only proof they have of what Ms. Marks actually consumed is the word of her friend, their only witness in this case, Morgan Levin. Which brings me to my third and final question. Can we trust Morgan Levin? Well, members of the jury, you're going to learn that he was drunk that night. You'll learn he's told multiple conflicting versions of his story. You'll learn that he's here today in court after the plaintiff threatened him with a lawsuit. So when Mr. Levin takes the stand and I cross-examine him today, members of the jury, I want you to listen for 3 simple words. I don't remember. And that's why at the end of today's trial, I'm going to come before you again. I'll ask you to remember that you can't stop what you can't see. I'll ask you to find Sonny's Rooftop Bar not liable. Thank you.
Thank you very much. If we could now have folks go to speaker view and we'll hear for the first witness. Gallery view.
Your Honor, the plaintiff calls Morgan Levin to the stand. Good morning, Mr. Levin. Please introduce yourself to the jury.
Hi, my name's Morgan Levin, but my friends just call me MG. Mom wanted a girl.
Why are you here today?
Well, I'm here because my best friend is dead.
Do you have Exhibit 2 in front of you, Mr. Levin?
Yeah, I do.
What is it?
It was a picture of Jessica Marks, my best friend.
Would you say it's a fair and accurate representation of that picture?
Yeah, it is.
The plaintiff enters Exhibit 2 into evidence.
Any objection?
Without objection, Your Honor.
All right, Exhibit 2 is admitted.
How far back does your relationship with Jessica go?
Jessica and I, we've been best friends since middle school. We did everything together. We were inseparable. Even had the same birthday, January 20th, but she went to Drexel and I stayed here in California for school, UCLA. And she wanted to study criminal law because she just loved helping people.
Were you with Jessica on March 24th, 2019?
Yeah, that was the last time I ever saw her.
What happened that day?
She was in town for spring break and we went to a bar.
What bar?
It was this bar called Sonny's Rooftop Bar. It was in Malibu.
Did you drink that night?
Yeah, we did, both of us.
How did you order drinks that night?
Well, we had these fake IDs that we used.
Objection. Under Rule 403, confusing the issues. May I be heard?
Yeah, I would like some elaboration on that one.
Your Honor, pursuant to jury instruction 11, the defendant need not have known that Jessica Marks was underage in order to be liable. Now, my opposing counsel is introducing evidence about the fact that Ms. Levin and Ms. Marks used fake IDs that night. Whatever low probative value this may have is substantially outweighed by the danger that this will confuse the issues for the jury. It'll introduce the questions of whether or not my client knew these IDs were fake, whether or not my client regularly accepted fake IDs.
Your Honor, if I may.
You may.
2 things, Your Honor. First of all, the rule that opposing counsel cited, Rule 403 sets the bar extraordinarily high. You see, it needs to substantially confuse the jury. The prejudicial effect of a piece of evidence must substantially outweigh the probative value, which it doesn't in this case. It doesn't substantially confuse the issues. Second of all, Your Honor, we're not using this to show that whether or not Sonny Mehta or anyone at the bar knew Jessica Marks and Morgan Levin were minors that night. Rather, we're using this line of questioning to show that these were fake IDs. These were IDs that, as the defendant will testify later today, were bad fake IDs. Now, it is a rule that if a person arrives at a bar with a fake ID, they should not be let into the bar. We will show that the bar violated this rule. And this goes to show a pattern in which the bar violates rules, Your Honor. These are independent events. We're not using this to show that Jessica Marks was a minor or anybody at the bar knew Jessica Marks was a minor. We're rather to show a pattern, which is substantially more probative than any prejudicial effect it could have.
Response?
Yes, you may respond.
In that case, Your Honor, I'd amend my objection to Rule 404. Opposing counsel just stated that he's going to use Sonny's bar serving alcohol to minors blatantly for propensity. They're going to show that because they've broken the rules before, they're more likely to do it again. It's not relevant in today's case whether or not Sonny Mehta knew Jessica Marks was underage. It's not relevant whether or not they didn't care. Their character isn't relevant. What's relevant is whether or not the staff at Sonny's bar saw Ms. Marks was drunk and continued to serve her drinks anyway.
Your Honor, could I respond to that 404 objection?
You may.
Well, I believe that, Your Honor, first of all, Rule 404B says that evidence of a crime, wrong, or other act is admissible if it shows a number of things, if it shows knowledge, plan, motive, lack of accident. And that last one is key, a lack of accident. We're trying to show that this wasn't just some sort of accident that they were let in. We're trying to show that this was a lack of an accident in which Sonny's rooftop bar repeatedly breaks these rules, not just accidentally, but a lack of an accident, Your Honor. And that's why we're not using it for propensity. As a matter of fact, you can instruct the jury that we're not trying to show that simply because they've broken the rules before that they'll do it again. You can instruct them that we're only using this for a lack of accident.
All right. Since her age is not an element of the case, I'm going to sustain the objection.
Yes, Your Honor.
Move to strike that portion of the witness's testimony.
Yeah, I can't remember if he said anything, but if he did, it's stricken.
Yes, Your Honor.
Now, Mr. Levin, how much did you drink that night?
Well, I didn't drink that much, not nearly as much as Jess did.
Well, let's talk a little bit more about how much Jessica Marks drank. Do you have exhibits 11 through 16 in front of you?
Yes, I'm looking at them.
What are exhibits 11 through 16?
Well, there's some pictures that we took at Sonny's rooftop bar.
Would you say that they're a fair and accurate representation?
Yeah, that's exactly what the bar looks like.
The plaintiff moves to enter exhibits 11 through 16 into evidence.
Without objection, Your Honor.
All right, then 11 through 16 are admitted.
Could we have exhibit 11 put up on the screen? Now, Mr. Levin, from exhibit 11, what did Jessica Marks drink?
Well, that's the first bottle of wine that we split. I only had a glass, so she had around 3 to 4 glasses of wine. She finished the rest of the bottle.
We'll move on to exhibit 13. Based on this exhibit, what did Jessica Marks drink?
That White Claw back there, I don't really like carbonated drinks that much, so she had the White Claw and then the canned beer too.
At this point, after having drank 3 to 4 glasses of wine, 1 White Claw and a beer, had Miss Marks interacted with any of the staff at the bar?
She was starting to act a little bit more drunk, slurring her words a bit, and I saw her stumble and fall. She kind of fell down the stairs, and the owner of the bar, Sonny Mehta, caught her.
Did Sonny say anything?
I've known Mayan.
When Sonny caught her, he said, "We might need to cut this one off."
And did Ms. Mehta cut Jessica Marks off?
No, he didn't. I wish he did, but they just didn't care.
Oh yeah, they're out there.
Objection.
Kindly
Can I
pause.
just say that, could everybody make sure they're on mute?
That's
Who's
good.
not one of these four people, because I can hear other voices. First, I thought it was Sunny Mehta, but I realized it's not.
Objection. Your Honor, improper character evidence to the phrase, "they just didn't care." May I be heard?
Could you repeat the entire question?
It was just to the last portion of the witness's testimony, the phrase, "they just didn't care."
Okay, well, what was the question?
Your Honor, the question that I asked was, what did Sonny Mehta say when Mr. Levin described how Jessica Marks tripped down the stairs and into Sonny Mehta?
Okay, so that question was not objectionable. So you can deal with the witness on cross-examination.
Yes, Your Honor.
Now, Mr. Levin, we'll keep going, but did Sonny Mehta cut Jessica off?
Never. Sonny never cut either of us off. They never stopped serving us.
Based on Exhibit 15, what did Jessica Marks drink here?
Well, like I said earlier, I don't really like White Claw, so Jess had that other one too on the table.
And based on Exhibit 16, what did she drink here?
She had another White Claw.
Now, at this point, how was Jessica Marks acting?
Now she was starting to act a little bit more drunk, you know. She was being loud, slurring her words, not making the most sense. She was acting pretty out of it.
Did you happen to get a video of Jessica?
Yeah, I wanted to remember the night. So I took a video for our Instagram.
Do you have Exhibit 10 in front of you?
Yeah, it's pulled up right on my screen here.
Would you say it's a fair and accurate representation of the video you took?
Yeah, that's how she was acting it at the bar.
The plaintiff enters Exhibit 10 into evidence.
Any objection?
Without objection, Your Honor.
All right, we'll take Exhibit 10 as an exhibit.
Could we play Exhibit 10 for the members of the jury?
Hi everyone, Morgan and I are in Hollywood. We're in a bar. It's kind of like a Philly bar, except everything is really, really expensive. $10 for a seltzer. And everyone here wants to be a model or an actress. I'd like to thank the Academy. Mom and Dad, you've inspired me. Okay, well, go big or go home.
Mr. Levin, were there any symptoms of intoxication Jessica was displaying that night that are not in this video?
There are. She smelled heavily like alcohol, and at times her eyes were a bit red, and like I said earlier, she was stumbling around, losing her balance, and her hand-eye coordination wasn't the best.
And after Jessica Marks started acting this way, did Sonny say anything else to you and Jessica?
He did. After Jessica started acting a little bit more drunk, he said, "I hope this one's not driving."
Did she serve anything to you after that?
Yeah, he didn't even cut us off after that. He served us another round of shots. There were these green tea shots.
Mr. Levin, what happened after you left the bar?
Well, I called my Uber. I didn't really want to drive, but Jess was going to her car. She got in her car and it pulled off. My Uber followed her, and I saw her car drive over the divider in the highway and go straight into a ravine. I didn't know what to do, so I called the cops, and it was too late. My best friend was dead.
No further questions.
Cross-examination.
Yes, Your Honor. Good morning, Mr. Levin.
Morning.
I want to start off by talking about why you're in court today. You know the plaintiff in today's case is Ms. Marks's mother, right?
Yeah, Ethel.
And after Ms. Marks died, the plaintiff threatened to sue you, right?
Yeah, she did. I was with Jessica that night, but she's not suing me. So.
And sometime after the plaintiff threatened to sue you, you sat down with her attorneys.
Yeah, I did sit down with her attorneys. They always say you should get a lawyer. So
To be clear, Mr. Levin, those attorneys don't represent you. They represent Ms. Marks, correct?
yes, they represent Miss Marks, but I wanted to speak to an attorney too.
That meeting with them lasted 2 to 3 hours, right?
I'd say around that length. Yeah.
We don't have any record or transcript of what went on in that meeting.
Not that I know of. I don't think anybody was recording it.
And Mr. Levin, just the day after that long off the record meeting, you sat down to give your deposition for this case, right?
Objection, Your Honor. Pursuant to Rule 403, we believe that this line of questioning is misleading the jury entirely. We believe that this line of questioning is trying to insinuate that in some way, this off-the-record meeting with two law-practicing individuals caused Mr. Levin to somehow change his testimony. We don't have any evidence for that. In fact, you can ask Ms. Connors today if there's any foundation for it, and there will be none. It's a completely foundational, it's a line of questioning that really has no foundation and only prejudices the jury into believing that Mr. Levin somehow lied because of what happened in that off-the-record meeting.
Counsel, you flashed his testimony on the screen as he was giving it. Overruled.
Yes, Your Honor.
Now, Mr. Levin, I want to talk about how that meeting might have affected your story. Because a few moments ago on direct examination, you were pretty sure that your friend had a lot to drink that night, weren't you?
Yeah, I mean, she had more to drink than I did. She had a pretty good amount.
You listed everything you said she drank up on the screen, right?
Yeah, you guys saw pictures of everything that we had on our table, but
Mr. Levin, that hasn't always been your story of that night, has it?
it's not a story. I'm just here to tell you what happened. You know, Jessica was my best friend.
Well, let's talk about what you said on March 24th. Because that night you spoke to the police, didn't you?
Yeah, I did. It's not something I like to think about.
Mr. Levin, you didn't tell them Ms. Marks was drunk, did you?
No, my best friend had just died. I was confused and scared. I was just worried if Jessica was okay. I didn't tell them the full story of what happened that night.
What you told the police on March 24th, before you were threatened with a lawsuit and before you sat down with the plaintiff's attorneys, was that Ms. Marks had only had a few drinks all night long. Right?
I mean, yeah, that's what I said. That's not what I was thinking about. My best friend had just driven into a ravine. That's not what was on my mind.
When they asked you directly how much Ms. Marks had had to drink, you said she had 3 drinks, right?
Yeah, that like I just said, that's not what was on my mind. When I thought about the night, you could see the pictures of how much we both drank. I wasn't thinking about that at the time.
Well, Mr. Levin, since your story that night was that Ms. Marks only had 3 drinks, I want to talk about who might have had the rest of those drinks in those photos. Because the truth is, you were more drunk that night than you just claimed in response to Mr. Pandey's questions, weren't you?
I was at a bar with my best friend. I wouldn't say I was extremely drunk. I was a little bit buzzed, I guess.
You're actually having a lot of trouble remembering what happened that night, aren't you?
I don't like to remember what happened that night. That's the night my best friend died. I try and block it out. I'm sorry.
Let's talk about what you said in your deposition. You were asked what order you ordered your drinks in, right?
Yeah, I was.
You don't remember?
No, I don't remember the exact order. I ordered some drinks 2 years ago. I'm sorry.
Mr. Levin, you remembered some quotes that Ms. Mehta supposedly said on direct examination, word for word, just fine, didn't you?
Yeah, I do. Those really stuck out to me because if they had cut her off, things would have been different. So I do remember them saying Sunny.
Mr. Mehta, you remember, excuse me, Mr. Levin, you remember that you spoke to Sonny Mehta that night, right?
Yeah, he took our orders and dropped off our drinks. Me, him, and Jessica spoke a good amount that night.
You spoke a good amount that night, but you were asked how you would describe his voice, or her voice, weren't you?
Yeah, I was.
You don't remember.
Not exactly. Again, it was 2 years ago and there was loud music at the bar, so it was kind of hard to hear at times, but we made it work with ordering.
You were asked what Miss Mehta was wearing, weren't you?
Yeah, I was. But again, it was 2 years ago and I really try not to think about it. You have to understand that that was my last night with Jessica.
Mr. Levin, you don't remember.
Like I just said, I'm sorry, I don't remember.
You were asked where the other customers were seated at the bar that night, weren't you?
Yeah, I wasn't really paying attention to that.
You don't remember where any of them were.
Not exactly where everybody was seated, but there were around 10 other people, maybe 12, I think.
You were asked how much you ate, right?
Yeah, I had a,
You don't remember.
no, I don't. I remember, I think Jess had In-N-Out that day or something, and then we had some chips and guac, but I don't remember what I had for lunch on a day 2 years ago. I don't know.
Mr. Levin, you were driving right behind Jessica Marks as she left that parking lot, weren't you?
I wasn't driving. I was in my Uber.
You were right behind her, yes?
Yeah, I watched her go over the divide to the highway.
And you were asked in your deposition whether she was swerving as she left that parking lot, weren't you?
Yeah, I was, but it was pretty dark that night.
You don't remember.
Like I just said, it was pretty dark. I couldn't exactly tell if she was swerving or not. No, I don't.
And Mr. Levin, until I showed you that police report a few moments ago, you didn't remember what you told them, did you?
Not exactly how many drinks I said. Again, that's not what I was thinking about. My best friend had just died. I didn't care how much she drank. I just told them all that I could.
To be clear, Mr. Levin, when you were asked in your deposition what you told the police, you responded, "I don't remember," correct?
I was a little bit buzzed. I didn't remember. I just said that.
Thank you. No further questions at this time, Your Honor.
Redirect for this witness.
Yes, Your Honor. Mr. Levin, why is it that you can't remember all these things Ms. Connors pointed out?
And it was a really hard night for me. I try and block it out, but I was feeling a little bit buzzed. I remember what I can, and I'm here to tell you what I can.
Nothing further.
All right, any recross?
No recross, Your Honor.
All right, thank you, Mr. Mehta, you're excused.
Thank you.
If the plaintiff rests, the defense is ready to call our first witness.
Well, we're gonna find out.
Yes, Your Honor, the plaintiff rests.
Okay, then I'll hear from the first witness.
At this time, the defense calls Miss Sunny Mehta to the stand. May I proceed?
Whenever you're ready.
Good morning. Could you please introduce yourself for the members of the jury?
Hi, my name is Sunny Mehta, and I'm 27 years old.
What do you do for a living?
Well, I'm an entrepreneur. I used to be the owner of Sunny's Rooftop Bar in Malibu. I'm currently taking my shot at Hollywood and working on building my movie production company.
And Miss Mehta, do you know why you're in court today?
I do. In March of 2019, there was a tragic accident after someone left my bar, and I'm just here to say what I know.
And before we get into the details of that night, I want to be perfectly clear. Did Jessica Marks seem drunk to you at any point that you served her alcohol that night?
No, I served her drinks. I took her orders. Jessica Marks looked fine.
Okay. I want to talk about some things that have happened today in court. Did you hear Mr. Levin's testimony?
I did. I was in.
Mr. Levin testified that Ms. Marks fell into you stumbling down the stairs. Did that happen?
No, that never happened that night. I was at the bar that whole night for that evening, and Miss Marks was fine. I never saw her stumble, and that incident never happened.
Mr. Levin testified that you said you might need to cut Ms. Marks off. Did you say that?
No, I had no reason to believe that I need to be concerned about Miss Marks. I never said that.
And Mr. Levin testified that you said you hoped Ms. Marks wasn't driving. Did you ever say that?
No, ma'am.
Now that we've clarified what didn't happen that night, I want to talk about what did happen. When did Jessica Marks come into your bar?
Jessica came into my bar at around 9 p.m. that night. She was with her friend.
Do you know who her friend was?
Yes, I believe she introduced herself as Morgan Levin.
Let the record reflect I'm displaying copies of what have been pre-marked as exhibits 8 and 9 constructively outside the presence of the jury. Do you recognize these photos, Ms. Mehta?
Yes, these are pictures of the bar I used to own, Sunny's Rooftop Bar. Exhibit 8 is a picture of the rooftop, and Exhibit 9 is the inside of the bar when you first walk in.
Do they accurately reflect what your bar looked like on March 24th?
Yes, except for the fact that in Exhibit 8, it's daytime, whereas it was evening that night on March 24th. But other than that, they look accurate.
We move to enter exhibits 8 and 9 into evidence, Your Honor.
Any objection to 8
Without objections, Your Honor.
and 9? Same?
Yes, Your Honor.
All right. 8 and 9 are admitted into evidence.
Now, Ms. Mehta, where were Mr. Levin and Ms. Marks seated at your bar that night?
Well, Mr. Levin and Miss Marks, they were on the rooftop that night. That's where they took their orders, and that's where they served their drinks. I served their drinks. They were seated on Exhibit 8. That's the rooftop. They were seated in the chair on the far right corner. They had a table there.
Were you up on the rooftop all night long?
No, while I do like interacting with my customers and serving them drinks and taking their orders, I do not spend the entire time on the rooftop. I have to go downstairs to, mix the drinks sometimes and grab the drinks. So I did not spend the entire time on the rooftop.
And when you are downstairs, that photo on the right, can you see the rooftop area?
No, I can't from there.
And when you were on the rooftop, did you give Ms. Marks, Mr. Levin your attention the entire night?
No, I didn't. I had to, take other customers' orders, serve other drinks. There were about 10 to 12 other people at the bar that night on the rooftop. I wasn't giving them my attention there the entire night.
I want to talk about what you saw when you did go talk to Mr. Levin and Ms. Marks. As a bartender, can you typically tell when someone is drunk?
Yes, that's actually one of the most important things that we as bartenders and my employees are taught. We're trained to look for signs of intoxication in customers, and we go through a training course.
Based on your understanding, how do you recognize if someone might be drunk?
So there's some typical, signs that we're trained to look for, and these include slurred speech, being obnoxiously loud, loss of coordination, stumbling around, and many other symptoms.
Ms. Mehta, I want to talk about how Jessica Marks seemed to you on March 24th. At any point that you interacted with Ms. Marks on March 24th, did she have red or watery eyes?
No, she didn't. If I would have seen that she had red or watery eyes, I would have, I would have been concerned and I would have cut her off.
And at any point that you interacted with Ms. Marks, did she ever slur her words?
No, she did not.
Did she ever stumble?
No, like I said, if any of those symptoms would have shown up, I would have definitely done what I usually do with other customers who display those signs, and cut her off.
We've talked about how Jessica Marks seemed to you. I want to talk about her friend, Mr. Levin. Did Mr. Levin ever display red or watery eyes?
Mr. Levin was a different story that night. I was a little concerned about Mr. Levin. He certainly looked buzzed. You could tell the alcohol was affecting him, and I was concerned about him. I did notice that he had red or watery eyes.
Did he ever slur his words?
Yes, I believe there were instances where he was slurring his words, and I was concerned about that.
And did Mr. Levin ever stumble?
Yes. Actually, when they were walking down the stairs, Mr. Levin and Jessica, when they were leaving the bar, Mr. Levin stumbled on the stairs, and I was concerned about that.
Let the record reflect, I've placed 3 red X's on my demonstrative to represent the symptoms that Jessica Marks did not exhibit, and 3 green checks to represent the symptoms Morgan Levin did exhibit. Now, Ms. Mehta, you mentioned you saw Mr. Levin and Ms. Marks on their way out. Did you talk to them?
I did. Like I said, I saw Mr. Levin stumble, and I wanted to make sure everything was okay. I was concerned about them a little bit. So I asked them who would be driving.
Who was driving?
Luckily, I learned that Mr. Levin wouldn't be driving. So I was glad to hear that Jessica, Miss Marks, would be driving instead.
And when Ms. Marks left your bar, did you have any fear at all that you might get into a car crash?
No, like I said, I was glad that she was the one driving, because to me, she looked perfectly fine. It looked like she, was doing okay that night. And then I didn't have any reason to believe that she wasn't okay.
Thank you. No further questions at this time, Your Honor.
Okay, cross-examination.
Yes, Your Honor. Ms. Mehta, Ms. Connors just showed you a visual of what symptoms Mr. Levin was showing that night versus what symptoms Ms. Marks was showing that night. Could we have that up on the screen, please? Now, throughout the course of today's trial, Ms. Connors has said that you can't stop what you can't see. But you saw Mr. Levin have red and watery eyes, right?
I did see that. He looked a little buzzed that night.
You saw Mr. Levin slur his words.
I did.
You saw Mr. Levin stumble.
Yes, like I mentioned, he certainly looked like the alcohol was affecting him, and I was concerned about that.
But you didn't stop serving Morgan Levin, if that was the case, right?
Objection, relevance, may I be heard?
No, overruled.
Yes, Ron.
Ms. Mehta, you saw all these signs, but you didn't stop serving Morgan Levin, right?
No, I didn't. Mr. Levin looked buzzed, but I didn't have any. There were no substantial signs that would cause me to be, really, really concerned about Mr. Levin and cause me to believe that I needed to cut him off. But he certainly looked buzzed.
But Ms. Mehta, you said if you saw these signs, if you saw Jessica displaying these signs, red and watery eyes, slurred words, stumbling, you would have cut her off. But Mr. Levin showed these exact same signs and you didn't cut him off?
I didn't cut Mr. Levin off because he displayed a little bit of these signs here and there. Again, it's not an objective thing. You have to be there and see it in order to make that decision as a bartender to stop serving someone. And although I was concerned about Mr. Levin, I didn't have the degree of concern that would be necessary for me to make the decision to put down the hammer and cut someone off.
Now I want to talk about something else you said on direct examination. Could we have Exhibit 8 put up on the screen, please? You said there were 10 to 12 other people sitting on this rooftop, right?
Yes.
So you couldn't pay your full attention to Jessica Marks and Morgan Levin that night, right?
No, I couldn't.
So, I mean, you saw Exhibit 10 earlier, which was a video of Jessica Marks, right?
Yes, sir.
And you weren't there when that video was filmed, right?
I was not there when that video was filmed.
So it's entirely possible Jessica Marks was showing the symptoms of intoxication, but you were busy, but you were with the 10 to 12 other people, right?
It's possible. I did not see her acting that way at any point that night, so I wouldn't know.
But as the owner of a bar, it is your duty to look out for these signs, isn't it?
Yes, it is. I make sure, as a bartender to, whenever I'm serving drinks or taking orders of any customers, I keep an eye out for any of those concerning signs.
And let's talk a little bit more about these signs, shall we? The symptoms for when someone is obviously intoxicated, that includes being loud, right?
That is one of the symptoms.
Slurring speech,
Yes,
smelling like alcohol,
that is also one of the symptoms that can be shown.
having red eyes is one of them,
Yes.
and lacking hand-eye coordination, right?
Yes, sir.
Now, you say that Jessica Marks wasn't obviously intoxicated to you, but I want to show you this video that we just talked about earlier. Can we have that put up on the screen, please?
I'd like to thank the Academy. Mom and Dad, you've inspired me. Okay, well, go big or go home.
Now, you heard earlier that this video was taken at around 11 p.m., right?
That is what I heard today in court. Yes.
And yet, even you still serve Jessica Marks and Morgan Levin alcohol after 11 p.m., correct?
I did serve them alcohol around 11 p.m. But again, I had never seen that video, or I'd never seen her acting that way.
But it's true that if you saw her acting this way while you were dealing with the 10 to 12 other people that night, you would have been concerned, right?
I might have been concerned. Again, like I mentioned before, it's not as objective as, it may seem. You have to be there. I would have to be able to gauge the situation and see if she really was acting that way, if there was a consistent pattern of that behavior. I would have to be there in order to make that call.
Finally, Ms. Mehta, I want to talk about what could have caused Jessica Marks's death. You're aware that at the time of her death, Jessica Marks's blood alcohol concentration was 0.16.
It was 0.16, I believe, at the time of her crash.
You're aware this means a person is intoxicated.
Yes, that means they're intoxicated. I don't know if that means they, are displaying any signs of intoxication.
So another person saying that Jessica Marks would have had to have shown signs of intoxication, signs of obvious intoxication with a blood alcohol concentration of that level, they would be wrong, Ms. Mehta?
I wouldn't completely know. They might be, because that certainly is 0.16 is certainly a level of, high intoxication. However, I am aware as a bartender that, different people display different signs of intoxication depending on their body type and all of that. I'm not a doctor, but I am aware of that basic concept. So it would depend, but I certainly agree that there might be a possibility that, considering that high amount of BAC, there might be some signs of intoxication.
Your Honor, the plaintiff moves to enter Exhibit 27 into evidence.
Any objection?
Yes, Your Honor, hearsay.
All right.
Your Honor, if I may.
You may.
Well, there's actually a couple of things to talk about in terms of hearsay, Your Honor. First of all, the declarant of this document is Gray Grimes, who pursuant to Rule 804A has already been declared as unavailable. And furthermore, Your Honor, regardless of the declarant's availability, Rule 8034 says that if it's statements made that are reasonably pertinent to a medical diagnosis, there are exceptions to hearsay, Your Honor. This document does exactly that. It's statements that are reasonably pertinent to a medical diagnosis. And furthermore, Your Honor, if there's certain parts that counsel would like redacted that may or may not be, by counsel's definition, of reasonably pertinent to a medical diagnosis, we'd be more than happy to do that.
Response?
Yes, please.
I'll take those one at a time. First, regarding the unavailable declarant exception to hearsay, there are two hurdles which hearsay statements must clear in order to be exceptions under that rule. We agree that Gray Grimes is unavailable under 804A, as my opposing counsel stated, but this specific testimony does not fall under any of the specific kinds of statements which are exceptions under 804B. It's not prior sworn testimony or anything like that. It's not a statement under belief of imminent death. In terms of the statements pertinent to a medical diagnosis, That exception to hearsay is in place for statements which a patient makes to a doctor, statements which are pertinent to their own medical diagnosis. That hearsay exception doesn't apply to a doctor speaking generally about symptoms someone may display. This is an expert witness. They're trying to essentially have this expert witness testify without giving us an opportunity to cross-examine them. If all expert witnesses' testimony was available like this, we never have to call them to court. We never have to cross-examine them.
Your Honor, if I may.
Sure.
Your Honor, I'm looking at Rule 8034 right now, and it doesn't say anything about a doctor and a patient. All it says that it needs to be reasonably pertinent to a medical diagnosis. That's exactly what this document does, Your Honor. The medical diagnosis that Mr. Grimes is describing in this document is that Jessica Marks was obviously intoxicated, that medically she showed she had a blood alcohol concentration of 0.16, which would make it reasonably pertinent that the blood in her alcohol was what caused her death.
Response?
No, that's not necessary. I'm not going to let you put this into evidence without giving counsel an opportunity to cross-examine. So sustained.
Yes, Your Honor.
Yes, Your Honor. Well, in that case, Ms. Mehta, I want to show you what's previously been entered as Exhibit 23. Now, it says here that the blood drawn at the scene of the accident indicated Jessica Marks's blood alcohol concentration was 0.16. In California, it is illegal to drive with a blood alcohol concentration of 0.08 and illegal for someone younger than 21 to drive with a blood alcohol concentration of 0.01. I read that correctly, didn't I?
Yes, sir.
So Jessica Marks had a blood alcohol concentration of 16 times what it should have been, right?
Yes, she did.
But you're still saying that she didn't show any signs of obvious intoxication despite having a blood alcohol concentration 16 times more than what it should have been, right?
Well, I don't know her BAC while she was at the bar. I believe if I'm reading that correctly, her BAC at the time of the crash was 0.16. So I don't know what her BAC was, while she was at the bar, but yes, she wasn't displaying signs of intoxication to me while she was at the bar.
No further questions.
Okay, redirect.
No redirect, Your Honor. At this time, we ask that our witness be allowed to step down and rest our case in chief.
All right, yes, you're excused. Thank you very much. And I think the rules are I'm not supposed to give recesses. So is the plaintiff ready to give closing statement?
Yes, Your Honor. Could I have a moment to readjust?
You certainly may.
Your Honor, I ask that any time I have remaining be reserved for rebuttal. They didn't check, they didn't stop, they didn't care. See, that's what today's case is really about. Ms. Connors came before you and told you that you can't stop what you can't see. But see, I talked to Sonny Mehta just a few moments ago, and Sonny Mehta said that there were 10 to 12 other people on the rooftop that night, and that could have been why she didn't see Jessica Marks displaying those symptoms of obvious intoxication. But that doesn't change the fact that Jessica Marks was obviously intoxicated that night, members of the jury. They didn't check, they didn't stop, they didn't care. And that's what led to Jessica Marks's death. But we couldn't just tell you that the defendant didn't check, didn't stop, and didn't care. We had to prove it. We had the burden of proving that the defendant overserved and intoxicated Jessica Marks, which led to her death. And we had to prove each of these three elements by a preponderance of the evidence, meaning that each one is more likely than not. Now, what does that mean? More likely than not. I said that a lot over the course of today's trial. And to understand what it means, imagine the scales of justice, in which all it takes to shift the scales to one side or another is a feather's weight. But today, the evidence against the defendant has been far more than just a feather's weight, members of the jury. I want you to think about what we as the plaintiff have presented to you today and compare that to what the defense has said. And ask yourselves, which is more likely? Which is more likely? That the defendant didn't care to check and identify Jessica Marks's and Morgan Levin's IDs, or that the defendant somehow accidentally served them drink after drink after drink? Which is more likely, that Jessica Marks got behind the wheel of her car because she was intoxicated enough to make the wrong decision, or that she did it because she knew what was going to happen and wanted to die? Which is more likely, that Jessica Marks died because she was overly intoxicated that night, or that she died in a car accident with a blood alcohol concentration of 0.16 that doesn't mean anything? These are the questions you should be asking yourselves, members of the jury. And when you do, it is clear that our case is more likely than not that the defendant didn't stop, didn't care, that the defendant didn't check, didn't stop, and didn't care. So let's go through specifically how we've shown you all of these elements. First, that Jessica Marks was obviously intoxicated. See, I talked to Sunny Mehta on cross-examination. Sunny Mehta said that the symptoms that she looks for are loudness, slurred speech, smell of alcohol, red eyes, lack of hand-eye coordination. Well, interestingly enough, members of the jury, these are the exact ones that Morgan Levin testified to. Morgan Levin said that Jessica Marks was loud. Morgan Levin said that Jessica slurred her speech, smelled like alcohol, had red eyes, lacked hand-eye coordination. If the symptoms Sunny Mehta described are the exact ones that Morgan Levin saw, that means Jessica was obviously intoxicated. And the defense wants to get up here and say that it was Morgan Levin who was intoxicated that night. Well, members of the jury, why didn't Sunny Mehta cut her off? Why is it that these are such big symptoms when it comes to Jessica Marks, but then they're nothing when it comes to Morgan Levin? Why is there some sort of double standard? Why is it that these standards aren't objected by Sunny Mehta? How come they change whenever it helps the defense's case? It just doesn't make sense. And don't just take Morgan Levin's word for it or Sunny Mehta's word for it. Look at Exhibit 10 for yourself. Jessica Marks looked so obviously intoxicated, so publicly inebriated, so clearly drunk in the defense's own words. So don't just take Morgan Levin's word for it or what the symptoms showed. Look at the symptoms yourself. The second, that Sunny's Rooftop Bar continued to serve Jessica Marks despite her being obviously intoxicated. You heard today that Morgan Levin that Jessica Marks had 3 to 4 glasses of wine, a White Claw, and a beer, and yet she stumbled down the stairs. Sunny Mehta says she's going to cut her off, but doesn't cut her off. And then after that, Jessica Marks has 2 more White Claws, and then the defendant says, I hope this one's not driving, but still continues to serve her shots. Time and time again, the defendant continued to serve Jessica after she showed symptoms of obvious intoxication because the defendant didn't stop. And the defendant didn't care. And the third and final thing we had to prove, that the alcohol is what led to Jessica Marks's death. We showed you that Jessica Marks's blood alcohol concentration, it wasn't 2 or 3 times more than what it should have been. It was 16 times more than what it should have been. If you're 16 times more intoxicated than you should be, members of the jury, it's more likely than not that you're showing certain symptoms of intoxication. Now, you heard from Morgan Levin today that Jessica Marks was a student. She was pursuing a degree in criminal justice. That's because she believed. She believed in this system. She believed in this process, and perhaps most importantly, she believed in you. And because the defendant didn't check, because the defendant didn't stop, because the defendant didn't care, Jessica Marks is no longer with us. And that's why today, in the name of Jessica Marks, find the defendant liable. Thank you.
Thank you, counsel. Whenever you're ready with your closing.
Yes, Your Honor. May it please the court, counsel, and members of the jury. Mr. Pandey just told you that we're here because of Ms. Marks's death. He told you that we're here because Sonny's rooftop bar didn't stop, didn't check, and didn't care. Well, members of the jury, the real reason that we're in court today is the plaintiff has been trying to find someone to blame for this tragedy all year long. First, they threatened to sue Morgan Levin. Now she's their star witness in a different lawsuit about the same incident. And at the end of the day, my opposing counsel said it best. He asked Miss Mehta, he confirmed our point that she wasn't able to pay full attention to Ms. Marks and Ms. Levin all night long. They didn't see anything was wrong. And members of the jury, you can't stop what you can't see. The plaintiff has sued my client, Sonny's Rooftop Bar, for wrongful death under the California Dram Shop Act. And here, members of the jury, I want to be really clear because their burden is very specific. This isn't a case about whether or not the bar cared. This isn't a case about whether or not they let Jessica Marks drive, like my opposing counsel said on his opening statement. This isn't a case about whether or not Miss Mehta kept serving Morgan Levin drinks. This is a case about whether or not the defendant saw Ms. Marks was intoxicated and kept serving her anyway. The plaintiff has to prove that to you by a preponderance of the evidence, and make no mistake, members of the jury, they have not met their burden today. So to show you why, I want to go back to those 3 questions I asked you earlier today. First, what did the bartenders actually see? Well, that's the most important question you need to answer. You heard that Miss Mehta spoke to Jessica Marks 10 times that. You heard she went up to her table, she cleared her drinks, she took her order. She didn't see anything wrong. Mr. Pandey said it himself. He said they didn't check. Members of the jury, this isn't a case about whether or not they checked. It doesn't matter in court today whether or not they checked. It matters whether or not they saw. Every time Miss Mehta went up to Ms. Marks, she didn't see anything wrong. She didn't hear her slur her words. She didn't see bloodshot eyes. And then Ms. Marks walked out of the bar and the bartenders thought she was safe to drive. They didn't stop her because you can't stop what you can't see. And they didn't see all of those symptoms that opposing counsel put up on their fancy demonstrative today, members of the jury, because Ms. Marks wasn't acting as drunk as the plaintiff wants you to believe. Which brings me to my second question. How much did Ms. Marks actually drink? Because we saw all those photos that the plaintiff showed you today. We saw what they listed on screen, but you didn't hear whether Ms. Marks actually drank all of those drinks. The plaintiff tried to tell you they know for sure how much Ms. Marks drank, for sure how much she was served, but members of the jury, their only witness, can't even get her own story straight. The night Ms. Marks died, Mr. Levin told the police Ms. Marks had only had 3 drinks all night long. She said one thing long before she was threatened with a lawsuit, long before she sat down with the plaintiff's attorneys, and she said another today in court. Which is it, members of the jury? And more directly, my third and final question, can we trust Morgan Levin? Because the plaintiff has staked their entire case on her testimony. And you know, it's hard to blame Mr. Levin for coming to court and testifying today. He's here after the plaintiff threatened him with a lawsuit. It could have been Mr. Levin opposing counsel was cross-examining today, and he knows that fact all too well. Think back to his direct examination. They had a great presentation, members of the jury. They had transitions. They listed things on the slide. Mr. Levin remembered specific quotes, word for word, without stumbling. But remember what happened when I cross-examined him. Members of the jury, Mr. Levin doesn't remember what order he got his drinks in. Mr. Levin doesn't remember what Miss Mehta sounded like. Mr. Levin doesn't remember what Miss Mehta was wearing. He doesn't remember where everyone else was in the bar. He doesn't remember how much he ate. He doesn't remember whether Ms. Marks was swerving, leaving the bar. And members of the jury, he doesn't remember what he told the police. There's a reason there are so many gaps in Mr. Levin's memory. Members of the jury, he was drunk the night Ms. Marks died. That's the witness that the plaintiff has staked their entire case on. A witness we know we can't trust. Now, Mr. Pandey has told you a lot about Jessica Marks today, and we all agree that her death was a tragedy. When something this tragic happens, when a young girl with her whole life in front of her swerves off the side of the road and crashes her car, it's tempting to do what the plaintiff did. It's only human to try and find someone to blame. But all that tragedy can't and doesn't change the truth of what happened. It doesn't change the fact that Ms. Marks was not obviously intoxicated that night. It doesn't change the fact that Mr. Levin simply doesn't remember what happened, and it doesn't change the fact that no one at the bar saw anything was wrong until it was too late. Members of the jury, you can't stop what you can't see. Find Sonny's Rooftop Bar not liable. Thank you.
All right, I don't know how much time you have for rebuttal, but I assume it's something.
Could I inquire as to how much time I have remaining?
Sure.
Per my time, the plaintiff has 1 minute and 20 seconds remaining.
Whenever you're ready.
You can't stop what you can't see. Ms. Connors is right. If I didn't see something, then I couldn't stop it. But what happens if I put my hand over my eyes? Well, I can't see anything right now, but I'm choosing not to see it. That's what today's case is about. Can we have the 3 questions that Ms. Connors just asked you up on the screen? You see, she asked, what did the bartenders actually see? And that's not the question you should be asking. You should be asking, what did the bartenders choose not to see? Because we showed you her blood alcohol concentration. We showed you a video. Are those just all coincidences, convenient coincidences, members of the jury? They can't all just be coincidences because that's not more likely than not. Second, how much did Jessica Marks really drink? I mean, we showed you pictures from that night, members of the jury. I mean, how does it make sense that you have a video where Jessica Marks is intoxicated and pictures of the alcohol? Well, that just makes it more likely than not that the alcohol is what caused her to act that way in the video. And third, can we trust Morgan Levin? Well, I want to ask you, did Morgan Levin lie when he got up on the stand? Was he impeached a single time? No, everything he said was consistent with his testimony from a deposition from 2 years ago, members of the jury. He's not lying. They didn't check, they didn't stop, and they didn't care. And that's why you must find Sonny's Rooftop Bar liable. Thank you.
Thank you, counsel. And this concludes the trial. And so